Hi friends, let us understand the section 44AD and section 69C interoperability of the Income Tax Act 1961. Now the interoperability between the section 44AD, that's a presumptive taxation for the business, and section 69C, that's the unexplained expenditure of the Income Tax Act 1961. And second issue is that whether assessing officer can make additions for the alleged unexplained expenditure when the assessee has filed income tax return under 44 AD presumptive taxation for the business. And for these questions, so there is a very popular judicial pronouncement of the ITAT Chandigarh bench, and the case title is Nand Popli versus the DCIT Chandigarh. And as per the Honorable ITAT bench has observed that if the 8% receipts are the deemed income of the assessee, the similar remaining 92% also the deemed expenditure of the assessee, meaning that actual expenditure may or may not be the same amount for this purpose of the taxation. So it may be a situation where the expenses may be less than 92% or maybe more than 92%. Now, as per section 44AD of the Income Tax Act, that is a presumptive taxations, and in this case the subsection 2 here, that any deduction allowable under the provisions of the section that's a section 30 to 38 shall for the purpose of subsection 1 be deemed to be allowable to the extent, or this has already given the effect to that extent, and no further deduction shall be allowable under these sections. So section 30 to section 38, which has been presumed to be allowed earlier, and no further deduction is allowed. And next, section 69C of the income tax, that's the unexplained expenditure, and as per 69C, that where in any financial year a assessee has incurred the expenditure. Now the honorable court has given the clarification on that. Can we say that assessee has incurred expenses which has filed the income tax return under the presumptive taxation? So assessee has not incurred expenses to the extent of 92% of the gross receipts. Now the next question is this: in this case the provisions of section 69C can't be applied. Asking the assessee to verify to the satisfaction of the unexplained expenditure to the amount of 92% also defeat the provisions of 44A.